Mora. Number 2 is Mageto Omari Mirieri. Mageto Omari, please answer in Kerandi. Sarah Kemunto. Number 5 is Moses Juma Zirengo. Number 6 is Jack Nyariango Ogao. Number 7 is Amphi Wende Abok. Number 8 is James Nyangau Yekobe. Number 9, Joseph Ochoki. Number 14, Umulokan. Contrary to Section 47A3 as framed in Section 48 of the Anti-Corruption and Economic Crimes Act Number 3 of 2003, particulars are that between 1st July 2014 and 29th of March 2018 in Nairobi City County within the Republic of Kenya, in the Deputy Commissioner General of Prisons, Assistant Director, Supply Chain Management Services, Principal Accountant, Chief Finance Officer, Accountant, SWADA, and Cleaning Supervisor 2 at the State Department for Correctional Services and sole proprietors jointly and severally conspired to commit an economic crime, namely fraudulent acquisition of public property, to wit, Kenya shillings 301,908,000 being payment for goods not supplied to State Department for Correctional Services. Mageto Omari Marieli, is it true or not true? Sarah Kemunto? Not true. Moses Juma? Jack Nyariango? Eric Kipkirui? Maureen? Count number 2. Suspend with Section 48 of the Anti-Corruption and Economic Crimes Act Number 3 of 2003. These are particulars for accused number 1. On 29 August 2016, within the Republic of Kenya, being a public officer, to which Deputy Commissioner General of Prisons, Kenya Prison Services, under the State Department for Correctional Services, you used your office to improperly confer a benefit of Kenya shillings 36,795,000 to unique supplies, being payment for goods not supplying to the State Department for Correctional Services. Count number 3, abuse of office contrary to Section 46, as read with Section 48 of the Anti-Corruption and Economic Crimes Act Number 3 of 2003. Particulars for accused person number 1. On 29th August 2016, within the Republic of Kenya, being a public officer, to which Deputy Commissioner General of Prisons, Kenya Prison Services, and the State Department for Correctional Services, you used your office to improperly confer a benefit of Kenya shillings 12,548,000 to Hygienic Ventures, being payment for goods not supplied to the State Department for Correctional Services. Count number 4. For accused person number 1, abuse of office contrary to Section 46 as read with Section 48 of the Anti-Corruption and Economic Crimes Act Number 3 of 2003, that on the 29th August 2016, within the Republic of Kenya, being a public officer, to which Deputy Commissioner General of Prisons, Kenya Prison Services, and the State Department for Correctional Services, you used your office to improperly confer a benefit of 21,580,000 to Omex Logistics, being payment for goods not supplied to the State Department for Correctional Services. Count number 4, Mageto Omari Mirieri. This is for you. Abuse of office contrary to Section 46 as read with Section 48 of the Anti-Corruption and Economic Crimes Act Number 3 of 2003. Particulars are between 29 August 2016 and 15 June 2017, within the Republic of Kenya, being an Assistant Director, Supply Chain Management Services at the State Department for Correctional Services, you used your office to improperly confer a benefit of Kenyan shillings 62,560,000 to Omex Logistics Enterprises, being payment for goods not supplying to the State Department for Correctional Services. Is it true or not true? Section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003. Particulars are between 29 August 2016 and 15 June 2017 within the Republic of Kenya, being an Assistant Director Supply Chain Management Services at the State Department for Correctional Services. You used your office to improperly confer a benefit of 51,003,000 to Hygienic Ventures, being payment for goods not supplying to the State Department for Correctional Services. Is it true or not true?
Not true.
Count number 17 within the Republic of Kenya, being an Assistant Director Supply Chain Management Services at the State Department for Correctional Services. You used your office to improperly confer a benefit of 73,342,500 to Unique Supplies, being payment for goods not supplied to the State Department for Correctional Services. Is it true or not true? October 2017, within the Republic of Kenya, being an Assistant Director Supply Chain Management Services at the State Department for Correctional Services, you used your office to improperly confer a benefit. Count number 9, still for the second accused person, abuse of office contrary to section 46 as read with section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2004, 780,000 to RIM East Africa Company, being payment for goods not supplied to the State Department for Correctional Services. Is it true or not true?
Not true.
Being an Assistant Director Supply Chain Management Services at the State Department for Correctional Services, you used your office to improperly confer a benefit of 25,650,000 between 29 January 2018 and 12 February 2018 within the Republic of Kenya, being a Principal Accountant at the State Department for Correctional Services. 48 of the ASECA, Sarah Kemunto Kerandi, between 29 January 2018 and 12 February 2018 within 342,500 to Unique Supplies, being payment for goods not supplying to the State Department for Correctional Services. Is it true or not true? Count number 3, October 2017, confer a benefit of Kenya shillings 12 million to Jocelyn General Supplies, being payment for goods not
addresses the court first.
With the accused ultimately attend court for trial, nothing has been presented to show the prospect of the second accused person or any other accused person not turning up for trial. Of retaining or surrendering their passports to court, any of the accused person being applied risk. A mere submission from the bar should not drive the court to accede. Your Honor, I also associate myself with my colleague, Your Honor, for perspective and context. You notice that these charges relate to transactions that there are several civil cases going on since, Your Honor, the accused persons should not be used as exhibits to assuage the public anger on the performance of the current government. The court should consider that instituting civil cases as way back as 2022 was appointed that the proper context was to pursue this case through the civil courts. Your Honor, this is an afterthought. And as we said, is an endeavor to parade the accused persons as exhibits of the war against corruption. When you consider all those circumstances, Your Honor, we request that you grant the most favorable bail and bond terms. Your Honor, for the record, I also appear for the 9th accused person. I represent him in the civil cases arising from the same circumstances. I managed only to contact him as I was getting to court. He was not aware, but is willing to present himself as early as Monday because he could not make it to court today. So for the record, I'm willing to appear together with the 9th accused person at the very earliest the court would give me. Your Honor, that would be all for the 2nd and 9th accused.
Start with a correction regarding appearance. I do appear for the 3rd, 5th, and 6th, together with Lynn Viengo, and I'm also holding brief for Mr. Wandugi. Your Honor, my colleagues have been very clear, and I think repeating the same things will only confuse the situation. I want to adopt the submissions by Mr. Wandugi and Mr. Mituga with regard to bail terms.
Complaints received by the EACC, Your Honor, are either through letters, email, anonymous persons, or walk-in clients, and they are not captured through an OB. So we have none in existence, and therefore we cannot issue what is not there. On the issue of handwritten and signed witness statements, the statements recorded by EACC, Your Honor, are typed. As the witness is narrating the events of the day, the statements are typed, printed, and signed. So again, there are no handwritten statements that we can supply, Your Honor. Your Honor, on the issue of disclosure, I have made a case to this court, a request to be allowed to supply our evidence in soft copy, owing to the voluminous documenting many charges. Your Honor, Article 52J of the Constitution, which deals with the issue of disclosure, it's clear that the accused persons will be informed in advance of the evidence the prosecution intends to rely on and have reasonable access to that evidence. Your Honor, the Constitution does not say the evidence must be in form of hard copy. Moreover, Your Honor, none of the defense counsel has demonstrated any prejudice whatsoever that will be occasioned to them if the evidence is disclosed in soft copy, Your Honor. Your Honor, for those very reasons, And there was the issue, Honor, that the accused persons are facing civil matters relating to the charges they are facing in court. Your Honor, Section 193A of the CPC guides me on this, that both civil matters and criminal matters can run concurrently, Your Honor. One does not bar the other from proceeding. And obviously, the accused persons have not been arraigned in court to serve as experts. I heard counsel use that term. Very disturbing, Your Honor. Lastly, I urge the court to consider my earlier submissions on stringent bond terms because of the colossal sums involved here. And again, for the accused person to deposit their passports in.
So the court has considered the charges hearing, the applications made by both the prosecution and the defense counsels. I have also considered the various responses and issues as raised by the counsels before court. And I wish to state that the court is alive to the provisions of the Constitution and all the applicable laws with regard to the issue of bond and bail terms. The court is also alive to the fact that the offenses herein relate to economic crimes, and these are issues that are of great concern to the public and the country at large. The court has also considered the fact that as much as the accused persons are not a flight risk, it is important that they deposit their travel documents and passports in court for the court to also keep track of the accused persons and the court to be aware whenever they are not within the borders of the country. So in that regard, the court is making orders as follows. Number one, that each accused person, the ones who are present today, that is accused 2, accused 4, accused 5, accused 6, accused 10, be released on a bond of Kenya shillings 7 million with one surety of similar amount, or cash bail of Kenya shillings 4 million. Each of the accused persons are ordered to deposit their passports or travel documents in court during the pendency of this matter. And I also want to reiterate that whenever they need to travel, the court will always be informed, and the court can always release the documents to them, and they can return them when they are back. Order number 3, that summons requiring attendance to issue to accused number 1, 3, 7, 8, 9, 11, and 13 to appear before this court on Monday, the 22nd of July, for plea taking. Number 4, that the prosecution and EACC to supply the defense with all the documents they intend to rely on in this matter, in hard copy where it is acceptable, and in soft copy where it is agreeable to the parties, mentioned on the 2nd of August 2024 to confirm compliance with the issue of disclosure of the orders above and further directions on the hearing date. That is all. Second is for plea taking for those who are not in court today. And then 22nd of August, 2nd of August is for us to confirm compliance with the disclosure orders. And that is all for the day. I wish you all a good day.